Thank you for joining us for this webinar on damages and loss calculations, which seeks to address the key factors that in-house counsel should know about damage and loss calculation in disputes and how to leverage that knowledge to achieve earlier resolution of those disputes. Before I introduce you to the panelists, I do just want to give a shout out to the road crew just down the road, who typically start jackhammering around about 12 noon. So if you hear that, many apologies. I will put my microphone on mute at that stage, but I did want to apologize in advance in case that happens. So we are joined today by Jim Cooley. Jim is a senior partner, mediator and arbitrator with Womble Dixon in their Charlotte office, and has also recently joined Miles Mediation and Arbitration in that new Charlotte office, which Miles have just opened. Jim's practice resolves around complex business disputes, and it's been his focus since joining Womble Bond Dixon, as it was before it was known as Womble Carlisle, back in 1985. In addition to Jim's many years of litigation experience, which include over 50 trials, Jim has a keen understanding of the alternative dispute resolution techniques that his clients need to resolve their problems. He served on the North Carolina Bar Association's committee, which designed and implemented North Carolina's court annex dispute resolution process, and serves on the counsel of the dispute resolution section of the North Carolina Bar. He has actively participated in the work of the International Institute for Conflict Prevention and Resolution, studying dispute resolution in the construction and financial services industry. Jim has represented clients in hundreds of mediations and arbitrations and is now certified as a mediator in North Carolina, specializing in complex business disputes and class actions. Jim brings a complete set of techniques and skills to evaluating and solving business disputes in an efficient and cost-effective manner. In recent years, Jim's practice has centered on the representation of financial institutions in a broad range of matters arising out of the 2008 financial crisis, which of course is highly relevant for what many fear will be happening later this year. He has frequently represented clients in class actions and multi-district litigation, in antitrust, unfair competition, wage and hour and securities fraud claims, as well as numerous corporate and partnership control disputes, particularly on behalf of both majority and minority interests. In addition to which, Jim handles commercial contractual disputes for a wide variety of business clients in the United States and also abroad. Jim's interest in constitutional rights litigation continues primarily on behalf of local governmental bodies. Next, I'd like to turn to Robert Taylor. Robert is a partner at Bennett Thrasher, which is a full-service CPA firm. Although it's based out of Atlanta, it has a national and international reach. Rob is a partner in Bennett Thrasher's dispute resolution and forensic department, with over 30 years of experience in the areas of business and equity interest valuations, mergers and acquisitions, fairness and compliance related valuation work, financial litigation services, and assistance to clients in strategic planning. His work has been in a wide range of industries with the emphasis on beverage, healthcare, manufacturing, distribution, real estate, construction service, textile, and not-for-profit segments. He is a certified public accountant and accredited in business valuations. He has been active in professional associations and currently holds membership in the American Institute of Certified Public Accountants and the Georgia Society of CPAs. He's a member of the Forensic and Valuation Services section, and he currently serves as a member of the mentor task force for the American Institute of Certified Public Accountants, and has served as the chair of the Forensic and Valuation Services as well. Prior to joining Bennett Thrasher, Rob was the founder and president of Taylor Consulting Group, where he and his service team serviced clients in the Southeast for over 25 years. He is the CEO of Open Arms Care Corporation from Tennessee, a member of the executive committee and a board member of the Atlanta Legal Aid Society. He is also an honorary board member and past treasurer of the Special Olympics Georgia and a board member of the Atlanta Ministry with International Students. He served in the past as a member of the executive committee and a board member of Ridgeview Institute, the chairman of the finance committee for Cherokee Town and Country Club, treasurer and board member of Compere Atlanta, now part of George West Mental Health Foundation, and a president of the Atlanta chapter of the Strategic Leadership Forum. Rob received the 2003 Public Service Award from the Georgia Society of CPAs. As for me, my name is Nigel Wright, and I'm a New York attorney. I'm a Georgia attorney and a solicitor of the senior courts of England and Wales. Yes, unfortunately, I did have to take all of those bar exams. I have 30 years of ADR experience and have been a senior partner at 2 AM 100 law firms on both sides of the Atlantic. I've also been in-house in various senior management positions at 2 specialty insurance companies. I'm a registered mediator and arbitrator with Miles Mediation and Arbitration, based out of their Atlanta office, but working nationally and internationally. I've been fortunate enough to have mediated just about every type of insurance-based dispute, as well as a significant number of commercial disputes and arbitrations. I still do work in private practice in a niche area handling Bermuda form international arbitrations. And now I want to introduce Sierra Marshall from Miles, who has kindly agreed to help us with the slide presentation. Now, I hope that you have been bearing with us, and I know it's a bit of a long introduction, but what I wanted to do, Sierra, if you wouldn't mind putting up the first slide, we're going to start with Jim, who is going to take us through some of the initial considerations that general counsel and in-house attorneys will need to address at the outset of any valuation or damages dispute. Robert is then going to address the different valuation methods employed, and then how the courts and the parties in the damages disputes use these methodologies in practice. And then after that, Jim and I will talk about the advantages for those corporations that address damages earlier in a dispute resolution cycle, and how early mediation is generally as effective, if not more so, than post-discovery mediation, and how this translates into significant cost savings for the parties. Finally, before I hand you over to Jim, I need to give the usual lawyer disclaimer that the opinions in this website, although are not intended to be the provision of legal advice, etc. Jim, could I ask you to take us through your slides?
Oh, thanks, Nigel, and welcome everyone. I'm fairly certain that almost everybody who's attending this program today has, during the past few months, been very heavily engaged in the process, a process that I'm going to quickly outline for you. That is the careful review of your business's key contracts. With the heightened risk associated with contractual relationships in a time of COVID-19, I'm suggesting that you look beyond the dispute resolution clause and ask yourself, before the dispute or at its outset, what are my remedies? Sierra, could we have the first slide up there? I'm going to run through quickly a few questions for you, which I'm sure you are already asking. Does the contract purport to exclude certain remedies? The typical one is consequential damages. Is that exclusion enforceable? Does the contract have a choice of law provision? And if so, is that choice enforceable? And if not, for example, think about the battle of the forums under the UCC sales agreements. What state's law does apply to your dispute? Is the choice of law provision broad enough to cover tort claims arising out of the contractual claims that may be involved? Let me give you an example. With the standard choice of law provision, and if you are in Delaware, you're probably okay with that kind of provision, where Delaware law covers both types of claims, including typical fraud claims arising out of the contract. Of course, there are exceptions. But if you're in New York, the courts are much more likely to look at the express language of the clause to make sure it is sufficiently broad to encompass, as they say, the entire relationship between the parties, that is both tort and contract. Okay, continuing on with our questions, is the choice of law provision broad enough to cover the procedural, i.e. think statutes of limitation, as well as the substantive law of the choice state? Sierra, let's have the next slide. Does the jurisdiction whose law applies limit in any way the available remedies? This subject is so broad that I wanted just to give you a few examples to try to get you to think a little bit about these kinds of issues. Let me turn to Georgia law. First of all, I'm somewhat hesitant to do that in this crowd, but under Georgia law and also Pennsylvania, there is a categorical bar for a new or established business to recover lost profits due to the level of the speculation deemed to be involved in making that determination. This is the so-called new business rule. It's certainly not true in every state, but it is true in a few. With that idea in mind and continuing on to the subject of lost profits, you may want to carefully evaluate whether you have an agreement that contains a consequential damages bar. If it does the clause also specifically reference a bar on the recovery of lost profits? If not, it could be that lost profits are recoverable as general or compensatory damages where the non-breaching party bargained for such profits, and they are, as the New York courts say, they are the direct and immediate fruits of the contract. Under New York law, for example, there is really no bright line between direct and consequential damages with respect to the recovery of lost profits. So let me run one more situation by you. You probably are all familiar with the Harvard Law Forum on Corporate Governance and its analysis of Delaware versus New York governing law. I'm sure many of you have heavily negotiated forum and choice of law clauses between New York and Delaware. And so you know that the statute of limitations on contract claims in Delaware is 3 years, while it's 6 years in New York. You've probably tried to contractually adjust these deadlines. But what about your remedies under best efforts covenants? Covenants for, quote, good faith negotiation. What about disclaimers of reliance? Are they enforceable? And what about the fraud exception to monetary caps on indemnification claims for breach of reps and warranties? In some states, in one state, they are enforceable, and another one, maybe not. There's even a difference in the long-standing equitable remedy of specific performance. In New York, you only have to prove entitlement to specific performance by a preponderance of the evidence. But your claim under Delaware law is a lot tougher. Clear and convincing evidence is required there. These are just a few of the examples, many of which you already know about, but that need to be thought about as you evaluate remedies. The last question here, are there conditions precedent to filing suit under the contract? This is important to know. For example, there may be a pre-suit mediation clause already in your contract. So let's go to the next slide, Sierra. What are the bars to full recovery? How does the duty to mitigate apply to this claim? For example, right now, you may be asking yourself whether disruption in supply chains going on throughout the world is going to have an effect on a party's ability to mitigate its damages. Are there statutory caps as to certain types of damages? Is the contract unconscionable? And this one, how is this jurisdiction that you have chosen or that you are subject to likely to treat what I call COVID defense claims? You've been thinking about them, acts of God and force majeure clauses, but then there are the impossibility defense, the impracticability under the restatement, the frustration of purpose under the restatement. And what about pending M&A deals and the assertion of the material adverse effect clause? For example, think about the recent failed merger between Sycamore Partners and Victoria's Secrets. Nigel, that's a quick run through. What do you think courts are likely to do with these kinds of contract defenses during this time of COVID?
Well, thank you, Jim. I think one of the things that we all need to bear in mind is that none of us actually know what the answer is. And obviously that's a great lawyer's response, but mitigation, for example, which is a requirement for all breaches of commercial contracts, applies equally to force majeure. However, how it will be applied in a straightforward contract may vary differently with force majeure. I can see a situation where courts are very forgiving in allowing arguments that it was not possible to mitigate because of the additional burdens that doing so would actually place on the parties. So I think that we might see quite a lot of case law around that particular area.
What about the civil unrest that's occurring now at the same time as COVID in some of our cities? Do you think that's going to complicate some of the COVID-related claims for example, for business interruption?
I think there's going to be an even greater tolerance for that, and so, and as I think there should be. So I think it's going to be very hard for a company to try and raise that as a say that there was not a force majeure situation. It's not something that I think the courts are going to, or anyone's going to want to see any party seeking to take advantage of at this time.
Well, let's look quickly at the next slide, Sierra. You already got it up there. Okay, so folks, I am really not trying to bring back bad memories of the remedies class that you had in law school, but I want to give you my checklist. Yours is probably more up to date, but this is the checklist that I think you can run through. On the left-hand side are the legal remedies of the damage remedies, some quasi-contract damage remedies at the bottom. On the right-hand side, the equitable remedies. And of course, don't forget the declaratory judgment action at the bottom. I want you to be thinking broadly about possible remedies. You have to know them, and you have to know how your jurisdiction of choice applies them before you can effectively mediate a claim involving damages or other available remedies. The question is, at the outset or early on, what is actually recoverable? Too often, it seems to me that parties wait until late in the discovery process to really begin to refine their damages analysis or their defense to a claim at a time when settlement opportunities have been lost and when they are facing the expert witness designation deadline of Rule 26 or its state law equivalent. So early on, you may need to invest time and resources to get an assessment of what you can actually recover, which is the time when an expert like Rob Taylor can often step in to help provide a little more certainty to your claim. Rob, you want to take it from there?
Thank you, Jim. The first slide that I have up here, and this is really more of a reminder that one of the first things that you do in any kind of damage estimate and assessment is that there are standards that apply. They apply specifically to expert testimony, but I really think that it applies to anyone with the company or associated with the case in the providing of opinions. The evidence must be reliable and relevant. The court or the party that's hearing the case will function as a gatekeeper, and there are really three rules that are under this Daubert type standard. One is that the testimony is based on sufficient facts or data. That's Rule 701. That the testimony is a product of reliable principles and methods, Rule 702. And then finally, reliable application of the methodology to the facts and data. So those standards exist and would be followed in all cases when a claim is being made. Next slide, please. The types of damages that are and this is not comprehensive, but employment disputes, and we're seeing a lot more of that, I think, in today's daily report in Fulton County. There's a lot of work being done in terms of employment area at the current time. Lost profits, and generally those are claims that are over a finite period of time until the period of damage is ended. So you can have interruption, business interruption, contract losses, interference, wrongful competition, and then in all cases, there's mitigation costs and other expense claims that can enter into the process. Another type of damage is loss in business value. Typically that's indefinite or permanent nature. A condemnation type case can be one where a part of property is claimed that impacts the business on a permanent basis, and there are many other examples. But in each case, the type of, very important that the application of the damage methodology needs to be based on the facts of the case, and certainly the law, as Jim has outlined. Well, what are your legal remedies in the jurisdiction? Next slide, please. Generally speaking, that the damages are measured based on the issue of, but for the alleged wrongful acts, what would have occurred? And you're putting the harmed party back in the position they were before. And punitive damages may also be available on top of whatever damages are measured. Next slide. Area of employment disputes, the measurement issues that you commonly run into is what were the baseline expectations of the harmed employee? How realistic are those baseline expectations? Is the person just came on board 6 months ago, does not have really a track record on which to base things, or have they been there a long time? You commonly look at and what are the comparative measures for measuring the compensation and other things for the employee. And what are the best sources? There's certainly outside sources and databases that you can access, but many times those comparative measures are internal to the company, within the industry, and are not obtained from databases. What is the duration of the damage period? How long before the employee is back in the position where they should be recovered from the wrongful acts? And what were the mitigation efforts that the employee pursued or even the company pursued in order to offset the claims? And again, the measurement is based on the facts of the case. And generally, a range of results is the most useful, particularly if you're going into mediation, so that the parties understand the range of possible outcomes and what are the facts or the issues that influence that range of outcomes. Next slide, please. I'm going to spend a good bit of time now on lost profits versus lost business value. Lost profits again, the damage period needs to be defined. What are the facts that indicate what that damage period is? That could be contractual. It could be the nature of the damage and how long it took to recover, say from some kind of physical damage or impairment in the company. The concept here is really incremental profits. So what you have to assess in the measurement, what are the expenses that may be variable versus fixed over the time period or over the volume of lost revenues and things like that that you're trying to measure. And really what I've seen more commonly now is the concept of cash flows versus profits. And so you need to also address and assess what are the working capital needs of the business, what are the fixed capital investment needs, what has been the history of these things, so that if you just went through a major capital expenditure program, you may not have those fixed capital investment needs going forward like you did in the past. Again, mitigation costs and other expense claims are included in the measurement. Income taxes are excluded generally. I would say always, but I'm sure there's an exception somewhere, because the award is generally taxable to the recipient. And you're looking at discounting future damages to the measurement date. So damages beyond the date of trial, typically, you're measuring damages up to the date of trial, and you have prejudgment interest on those damages at statutory rates. And then damages after the date of trial are discounted back to the date of trial using the weighted average cost of capital for the company as the discount rate. Next slide, please. In terms of lost business value, again, the issue is what is the measurement date that you have for doing that? And what was lost? Was it a business segment? Was it the whole business? And then you are also looking here at the entity value, not equity value. So very much like if you had damage to a house, you don't look at the mortgage and your net equity in the house to determine your loss. You're looking at what's the damage to the house. Here we're looking at the damage to the business and the business unit that has been damaged, and you're looking at it pre-debt on a debt-free basis, basically, but certainly not on a working capital-free basis or fixed capital investment-free basis. To determining value, the three common approaches that exist for valuation in general are an income or cash flow type approach, where you're looking at the income stream of the cash flows of the business going out into the future. You can also look at a market type approach in terms of valuation, which could be comparable to other transactions in the market or even to public companies and what they may be traded for, typically in terms of multiples of earnings before interest, taxes, depreciation, and amortization, or some other measure that's commonly used. And then finally, you have an asset-based approach, which is simply the value of the assets that are held in the business. It's important that under these methods, all should be considered, not all necessarily applied, but you do reconcile the results of the methodologies so that you understand what the differences are, and that gives credibility to whatever your final conclusion was in terms of the value of that entity or unit. Next slide, please. And again, I'm going to come back to the concept of cash flows versus profits. And you're again going to need, when you're looking at the value of the business, and if you're using a discounted cash flow type methodology, you do need to address the working capital needs, the fixed capital investment needs. And here you're looking at after-tax cash flows, because when you're measuring the value of the business unit, this is more like the sale of an asset or the value of an asset that's held. So under lost profits, you have a recovery of profits that you would have had, and the award will be taxable. Here, with the after-tax cash flows and measuring the value of the business unit, taxes do enter into it, and you're looking at what the value of that unit is. So taxes are considered, and the reward would typically be like the sale of an asset, what are the proceeds from the asset sale, and there may be capital gains or things of that nature. You're discounting the cash flows, again, back to the measurement date of trial, using a weighted average cost of capital for the business. When you're and so the measurement date is important. So it may or may not be the date of trial when you had the business loss, but it's, again, discounted back to whatever that measurement date should be under the law that you're following. Next slide, please. What's changed in damage calculation since COVID-19? One area that's changed in both lost profits and lost value is the cost of equity. There's certainly increased risk and uncertainties. What do investors require? What do debt providers require in terms of the returns that they require to provide capital to the business? That certainly could have changed, and it will change by industry and even segments within an industry. Also, the discount rates to some degree reflect the riskiness of the cash flows that are being projected. So there's two sides to this. One side is the risk to the providers of the capital, and the second is the risk of performance could change. So these are things that have to be considered today. They always were considered, but it is a much more volatile situation that you're looking at today than you did just a few months ago. The impact of the business risk, market conditions, uncertainty of performance on operating performance. The question there is what can reasonably be expected, and how do you support or how do you counter the position that the other side is taking, and how well have they considered these things? We have seen in the past many forecasts and projections of damages when we're on the defense side, where they really ignore a lot of the conditions that are going to influence the cash flows and business outcome. And those have to be considered or challenged, certainly in any kind of dispute. A final factor of what may have changed is restrictions on sources of capital to achieve the goals. So if a company is growing, and this may be a rapidly growing company or even early stage, if damages are recoverable, what are the restrictions on the capital that existed at the time of measurement versus what they would be typically? So you have to look at that. So these are just three areas that I think we, in our work, in valuing companies, and are spending a lot of time on considering, that certainly we considered them before, but more time is being spent today. Next slide, please. Nigel, you had a question, or?
Yeah, I was just going to ask, actually, Robert, I read an article the other day which said that nobody's going to be able to come up with a definitive answer about valuations going forward, given the economic upheaval which corporations and companies are facing at this time. And the only certain thing is that it'll end up being a reasonable approach, which I think, sorry to summarize your presentation in such a short soundbite, but I just wanted to reiterate that, notwithstanding that the approach needs to be reasonable, I think it's important to remember that it does actually have to be based upon the applicable law and precedent. So I don't think it's just going to be a question of throwing up a number. And I think that the arguments on valuation are still going to be centered around these issues, albeit the parties may be asked to be more flexible in terms of their projections, certainly at this moment in time. And I just want to get your thoughts on that, Robert, as you go on to your next topic.
That's absolutely true. It always comes down to facts and circumstances, and facts will be interpreted differently by different parties. But that's where the preparation comes in, how addressing these things in advance, early in the stage, what are the pros and cons to the expectations and cash flow estimates that the parties have, and what are the things that drive that, and really focusing on the range. We see extreme ranges now. the business is totally worthless because of COVID-19, or the business is, you know, going to recover within short order. And the answer is generally going to be somewhere in between. But the facts and circumstances, what others are doing in the industry, what the company is doing to lock in, that's going to change almost daily as facts unfold. So everybody's making their efforts to, you know, recover as quickly as possible and where they are in that cycle. And it also creates an opportunity in the mediation when things become more certain, then things become more locked in. So if you're trying to get the case settled quickly, then during this time of uncertainty, sometimes it's better to, you know, if you're on the claim side, be realistic about what you're claiming, and on the defense side, you know, things start recovering quickly, you may be in a much worse situation than you were before. But it's definitely facts and circumstances.
Yeah, and Robert, that brings us nicely to an issue which I know a lot of people who've been involved in commercial disputes have come across, which is where one of the party basically says, we did you a favor. Your company was losing so much money that even though we breached the contract, you don't actually have any loss. And I think you've got an example that will help explain one method to address that particular issue, which I thought touches on a lot of the issues that you have already raised.
Yes, this was a very interesting case in that it really did involve lost profits, consequential damages. It involved the value of the company, et cetera. And many people may be familiar with I won't name the parties, but it was a large textile manufacturer. The matter occurred in January of 2005, right at the first of the year, and it involved a train derailment in South Carolina at one of the major sites of this particular textile manufacturer. The manufacturer, by way of sort of background, they were competing with Chinese and others, and in the textile industry, the view was that the Chinese were essentially going to take over the entire textile production markets in the U.S. This client had always had a business strategy that, yes, that competition from offshore, China, et cetera, was going to be there, but that it was too risky for apparel manufacturers and others to source all of their materials from China or offshore because of the potential at the time of interruptions in the flow of goods, freight, dock strikes, things of that nature. In fact, this was at a time when there was an increased awareness or concerns about security risk in shipments. And so there was a lot of inspection of freight and ships and things of that nature defensively to prohibit bad goods or bad, you know, something harmful coming into the U.S. And there was some delay. So this particular company felt like at least 25% of the domestic demand or supply of materials was going to continue, and they wanted to be a fairly low-cost provider and an efficient provider in the U.S. and supply that 25% of the market. Interestingly, to your point, the defense on this was that the Chinese were going to take over the world, and in essence, they were going to go out of business regardless of what happened in this train derailment. And so therefore, there were really no damages to the business because the business is essentially dead already. And they both sides set out to address that issue. What was unusual about this train derailment is that it didn't hit anything. It didn't hit any physical structures of the client, but what it did do is it hit another train that was parked on the siding on the client's site, on the manufacturer's site, and 3 chlorine gas cars ruptured. And textile companies are located in low areas, and so chlorine gas, being heavier than air, settles into the site and stays there. And textile production, very highly automated, a lot of controls to make the process efficient. And chlorine gas is essentially hydrochloric acid when mixed with moisture, and it essentially fried all of those controls and mechanisms that were essential to the business. Remediation efforts took place immediately, and after it was a year and a half, actually, of remediation efforts and spending well over $100 million on those efforts, the insurance carrier and the client were no closer to complete remediation, they felt, and did not have a ready remedy in sight to provide a long-term cure for this. And certainly the funds were not being provided to do that. So the insurance carrier said, we've had enough fun here. We've spent well over 100 million, and we're going to give you some more money. And then we're going to join you and pursue the claims against the railroad for the damages. And the issue then was a lost profits versus taking of the business. I think the initial claims that were made by the plaintiff, and I was involved in a lost profits measurement, but there was also another expert in the case who testified to the value of the company. And the defendant argued after the initial reports that lost profits was a redundant element of damages. This was actually after my deposition, and we then moved into a different phase. Next slide, please. So what we ended up, the claim became that there was lost profits from the accident to the time of closing. The client decided to close the business in 2006, essentially almost 2 years after the accident occurred. So there was a period of time of lost profits, and I became the expert on these two issues, both lost profits and lost business value. And then what was the business, or would it have been worth at the time of closing had the accident not occurred? So it was what would it have been worth without the accident, and then what were the lost profits until the time that they decided to close the business. When they closed the business, what they essentially did was they sold off all their productive facilities and to others and settled up and really just went out of business. The approach that I've outlined here on the damage claim was one that people, our side of the plaintiff's side, was very skeptical of originally. They've never heard of something like this where you have lost profits and then all of a sudden you have a taking of the business a year and a half later. But factually, that was what happened. And so ultimately they agreed. That's how I wrote a rebuttal report to, there were 4 experts on the other side that were countering our initial claims. And we issued essentially revised rebuttal reports, and they challenged all 4 of us in federal court under the Daubert standards. The court ruled that the methodology that I was employing and the information I was using and all of that was reliable. And as a matter of law, the testimony was not going to be stricken. It was going to be allowed in full. And this became it was referred to in California as a slow death scenario, which is a period of damage followed by the death of the business. And the case during trial went on for weeks, I mean, maybe even months, but settled during the trial finally at a very amount that was very close to the damage measurement that we came up with. My takeaway on this is that you have to match the methodology to the facts. Our facts were very unusual, and it needed to, the damage measurement needed to fit that, and that's the process we went through. Now, from the time of the accident until we finally had the hearing and trial was almost 2 years or better. So early assessment of that, early discussions about that, and very often as the expert, you're asked to do X, and you don't really challenge the attorneys, but perhaps in the current environment, that's something that we need to do and really have that discussion. Is this really the right measurement, and does it really fit? I think that's my last slide. Let's double check.
Robert, thank you. I think that actually transitions nicely into Jim, who's going to now talk about the case for early mediation, because obviously the case you've just been talking about not only took a tremendous amount of time, but incurred incredible amounts of money, both in the initial remediation and subsequent resolution of that case, when ultimately the known financial metrics were available at a much earlier stage. So Jim, if you could kindly take us through the case for early mediation.
Well, Nigel, I think we could all likely agree that resolution of a dispute outside of the court or arbitration-based structure, if it can be achieved, provides some really significant opportunities. What Robert has just taken us through illustrates a number of these opportunities that perhaps were not possible in that particular scenario, but I would suggest are possible in a number of other scenarios that we can talk about. You can preserve business relationships before positions get really hardened. You can obviously save enormous cost. You can protect the reputational interest of the client, the brand, from adverse publicity. And you can oftentimes get a much quicker resolution where you're in control of the outcome and you're in control of the time that you and others spend involved in this effort rather than in running the business. So let's look at the next slide. What if I could demonstrate to you the following proposition? The longer in the process the parties wait to attempt a mediated settlement, the less likely they are to succeed. Let me try to do that. Like the courts of many countries and most jurisdictions in the United States, the civil courts of Singapore have a long-standing program of court-ordered mediation. But the courts face some interesting questions. What kinds of disputes are suitable for mediation? And when should a dispute be deemed ready for referral by the court for mediation? I put on the screen a citation to an empirical analysis of the Singapore court referral process, which was published in spring of 2018 in the Harvard Negotiation Law Review. It's a very detailed analysis. There are a number of conclusions we could talk about. I've selected a couple of them that I think are important for discussion. Let's have the next slide. First of all, cases are 50% less likely to reach a settlement at mediation if they are referred after some preliminary or interlocutory order has been entered, rather than before or at the close of the pleadings. In other words, after the parties start to fight it out in court and there are some contested applications and motions and so forth, the chances of success drop dramatically. So let's look at the next slide. The effect of contested interlocutory proceedings in and of themselves decreases the odds of a later settlement by somewhere around 22 to 23% for each contested application. So as positions get harder and harder and harder, the chances of success at mediation drop dramatically. So the conclusion, one of the conclusions from this study, which I'll quote for you. Well, put it in this context. Rather than refining the issues, as we traditionally do in this post-pleading discovery phase, in order to make settlements more likely, we know the case better, we know the facts better, We're refining the issues, and so finally we're ready to go to mediation. But this study demonstrates that a high degree of contested litigation probably entrenches the disputants in their positions and makes them less open to arriving at a mediated resolution. So I know that runs against the grain of a lot of trial lawyers. Nigel, does this study and this conclusion that I've tried to summarize here surprise you in any way?
I think it doesn't in this respect. I think most lawyers believe that after discovery, they have a much better handle of the facts. And if they have a much better handle of the facts, then they are able to better assess the risk to their particular clients of the positions that are being taken. However, what this study seems to suggest is that if you want to resolve your case, you should do so earlier, because you're not gaining any benefit from doing that. And which, now that you have presented it, not only do I endorse, but that makes even more sense. But yes, I was surprised when you first shared these slides with us, but it does make sense once you start to think about the rationale of early mediation, which is to resolve cases early and to save some of the expense and cost.
Well, let's take a look at one more slide here on this subject. What I'm really proposing to everyone on this call is that you need to add to your contract formation toolkit a mandatory mediation provision. Now, there are going to be some exceptions as to certain kinds of disputes or certain aspects of the dispute, injunctions, for example, but you can go a long way toward improving your chances of a mediated settlement with that kind of provision in place. You can identify potential mediators, for example, and agree on them in advance, or at least you can lay out the qualifications for those mediators. And then you can set that process up so that if it's not resolved, it leads to arbitration or it leads to litigation. It's not for every matter, I don't guess, but Nigel, I'm just wondering if in your broad experience, some kinds of cases come to mind right away that you don't think are particularly appropriate for early mediation.
Well, Jim, you touched on it earlier, which is those issues which require immediate injunctive relief, in my view, are not appropriate for mediation, because it may be a trade secret, it may be commercially sensitive information which has been disclosed or taken or misused. And so those sorts of things, I do feel that you've got to be careful, because it really comes down to drafting. And if you're going to include a mandatory mediation clause, which I'm all in favor of, you need to think it through. You can't just take a boilerplate clause and say, I'm good. Right. Because of these issues. It's not just things like injunctions, but think about the remedies that you're going to need in any given situation. And so it takes a bit of work, but it is worth it, because what you're doing is creating a clause which ultimately should save you very considerably in the long run.
Well, if anybody on the call is interested in some sample clauses along those lines, shoot me an email at Miles Mediation, and I'll send you a few clauses that I have seen used that I think are particularly good.
So, just in summary, first of all, thank you for bearing with us, because I know that we've got through a lot. But if we try and break it down into some takeaways for today, first of all, ensure that you know what your remedies are and what you're seeking. the applicable law in the jurisdictions that may apply to your contract are going to be really important. And what we would suggest is that you work with your finance team early. Too many times, litigators in particular turn to damages in discovery. What we're saying is that's too late if you want to save money, because you may have gone down the wrong route. Consider investing in your claims or damages assessment early on, potentially with your legal advisors. And the reasons for that are you want to protect a legal professional privilege. Now, obviously, a number of in-house activities will still qualify as privileged, but some won't. And so having a good relationship with your external legal advisors is going to be critical. And I would say equally critical to have the same type of relationship with your external forensic accountants, because what you're really looking to do is establish the legal provable damages, which may be vastly different from what the company considers it has either lost or is entitled to. And finally on that issue, I would say work as a team. It's not a question of using external counsel or using external forensic accountants in isolation. It's working together with yourself and your internal finance team so that you have a much better handle on the legal provable damages at an early stage. And finally, to Jim's point, what we say and what we see is that if you have a case that you want to resolve, and let's face it, most cases do get resolved, don't wait until discovery. If you've done the work beforehand, there is no reason for you to wait. All you're going to do is increase the costs and burden. And I appreciate that's always a scary proposition, because there's always the concern that something will emerge at a later stage that materially affects your assessment. The problem is that can happen at trial. It can happen just as much as it can happen after discovery. So based upon Jim's analysis and the statistical work that he's been able to delve into, it seems that there are tremendous benefits in trying to resolve your cases earlier. So with that, we are a few minutes away from the hour, and I wanted to thank the panelists, Jim and Robert, and of course Sierra Marshall for kindly transitioning us through the slides. And if anybody has any questions, please send us an email, or there's a Q&A button at the bottom. And if anyone would like to ask any questions, that would be great. But equally, I think all three of us would be happy to receive emails subsequent to this presentation on any issues that we can help you with. And thank you very much for your time.